Hello, this is Estates and Trusts Online Module 8B. We're talking about beneficial interests in trusts. We've just been talking about support trusts, and now we're going to move on and talk about trust provisions for beneficiaries who are problems. Okay, just to put this in context, we've outlined all of the requirements for a trust, focused on a beneficiary. We're focusing now on what beneficiaries actually get and what their rights are. These are the same objectives that you looked at in 8A. In this one, we are focusing still on the trustee's role, and we're identifying those trust interests that creditors can and cannot reach. Okay, remember Emmert versus Old National Bank. We were just talking about it. Frank Emmert needed money from the trust his father had created. Now, what if Frank Emmert had not been sick, but had just been really bad with money? Remember, he wanted $100,000 out of a trust that was only about $230,000 total. How can we protect the trust from Frank needing too much because he's squandered it all and now he has creditors beating down his door? In general, here's our problem. Anything a beneficiary can demand, a creditor can reach. So if a beneficiary could just pledge the trust interest, sell it, the payments would then go to the creditor, and we would no longer be supporting the beneficiary. We'll warm up with the problems from your book. Sandy creates a trust by transferring $100,000 to Thelma trustee. And the terms of the trust provide that Amy gets income for life, corpus to Bob at Amy's death. So in other words, to A for life, then to B. Can Amy assign her trust interest? Assign now means to transfer the right to the income to someone else. So could she sell her interest and get a pile of cash now instead of waiting for each payment from the trustee? Sure. She could sell it, she could give it away. It would still last for her life, but the payments would go to the transferee. And there are companies that will buy interests like Amy's. The price will depend on Amy's age and the current interest rate and how much money is in the trust. Okay, can Amy devise her trust interest? Leave it to someone in her will? Think hard about this one. There's not a lot of point to it, because when Amy dies, her interest goes, it just disappears. So there's nothing to devise, because by definition, a lifetime interest ends at death. How about Bob, our remainder beneficiary? Can Bob transfer his trust interest? Sure. Okay, Bob's interest is a future interest, so nobody's getting any money or anything now, but there are still companies and people who will buy it. What's the value? Well, it's the amount that you would have to invest today at today's interest rates in order to have the value of the corpus later when Amy dies. Of course, we're guessing when Amy's going to die, but that's okay. We're willing to take that risk. What if Bob dies before Amy does, and he does not have a will? Is his remainder interest part of his intestate estate? Yeah, generally speaking, it is. Generally speaking, Bob's heirs would inherit his interest. So this can be an asset of Bob's estate. Now, what would they get? They would still have to wait till Amy dies, and then they would get the corpus. Careful. If a state has adopted UPC 2-707 or a similar statute, there are survivorship requirements that make this more like a will. And remember, with wills, if you didn't survive until the testator died, that the gift would lapse unless we had an anti-lapse statute. Well, with trusts, if you don't survive, general rule is the interest goes to your estate. So it's really a different background rule, but the statute kind of revises things in the same way. UPC 2707 creates a substitute taker, and in general, it's going to go to Bob's descendants, or the transferor's residuary beneficiaries, or the transferor's heirs. But careful, it does not go to Bob's heirs. So it won't go to Bob's estate. So you have to draft carefully and always, always check your state law. Now, here's what we really care about. Can Amy's or Bob's creditors reach their interests? Maybe we represent the creditors. Maybe we're asking this question for a bankruptcy court. Or maybe we represent the trustee who just needs a clear answer before paying out money. General rule, whatever Bob and Amy can get, a creditor can get. So Amy's creditors could garnish her income payments, and Bob's creditors could take his remainder interest, in which case they will have to wait for Amy to die, or they could sell it now for cash. Now, if the rich relative who set this all up is still alive and just paying money to Amy, it would be easy to just not pay her if she had her creditors lined up behind her. And rich relatives certainly would not have to pay creditors directly. So spendthrift clauses allow us to build this into the trust. So let's take a look at Broadway Bank versus Adams, page 424. This is another old case with interesting characters. Now, Charles Adams owed money, and his creditors sued the bank as trustee to get it paid out of his trust fund. Okay, the trust was created, whoops, did I miss a slide? Yeah, trust was created by his brother Seth, who died first, and left $75,000. Now, this is in the 19th century, so that was a lot of money. Left it in trust, and also left a lot of money to charity, and you can read more about Seth Adams if you're interested. But Seth knew that he needed to protect Charles from himself, and so he included a spendthrift clause, which provided payments to be made to him personally when convenient, free from the interference or control of his creditors, my intention being that the use of said income shall not be anticipated by assignment. Now, Charles and his partner owed a debt of $10,000 back in the 19th century, which they had borrowed, and Charles, we're told, had no other assets. Okay, here's some irrelevant side notes. Charles had a wife in Massachusetts, but at this time he was living in Texas. He also had a girlfriend in California. And in August 1881, a son was born to the woman in California. Charles then changed his domicile to California to live with his new family and filed for divorce against the wife in Massachusetts. In April 1882, about 6 months later, the divorce was final in California, and Charles married the woman in California. Yay, 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 new life, etc. No. It turned out you had to have been a resident for 6 months before you could get the divorce in California, so he wasn't. And that means his divorce and his marriage probably were invalid. Just a tidbit. So, should Charles's creditors be able to force the sale of his trust interest? Because that was the goal, was to sell the income interest, satisfy the creditors out of the proceeds. This is exactly what's meant by anticipate by assignment. We kind of make a lump sum of all the money that he's going to get later, and he gets it now. Well, think about the creditors. Charles probably appeared to be a wealthy man. I mean, he did have a nice income coming in all the time, and creditors lend based on whether they think you can pay it back. So is it really fair to his creditors to keep this money intact for Charles and not pay them what he owes them? Court says, sure, we don't see any problem with that. Creditors should not lend based on apparent wealth. Creditors should do a better job of checking creditworthiness. Right? These documents, testamentary trust, are a matter of public record. They could have looked it up. It's very clear there that it can't be used to pay creditors, so they shouldn't lend based on that. Now, this trust was created by the more responsible brother, Seth. Could Charles create a trust like that for himself? Right? When he had money, take it all, put it in a trust, pay income to himself for life, but not be, not allow the trustee to pay him when it's inconvenient. In other words, lock it all up so that he can have it, but creditors can't? Well, the court says that's really a different question. Right? This was a trust created by someone else, and you kind of read between the lines and you see them saying, wow, we're glad we don't have to answer that one. Seth, however, can do this, and we respect his right to do this. He can restrain Charles' spending ability from the trust, just as he could if he were alive. So, spendthrift clauses that are created by another person are enforceable. Are they always? Should they always? We will take that up in the next set of materials, which I think we're going to do in class. So let's see where we've been. Trusts that pay income without other words are mandatory because the trustee must pay all the income. Same thing for annuity and unit trusts. Support trusts require a trustee to use trust funds for support, even when there is discretionary language. And a spendthrift trust in a trust, a spendthrift clause in a trust, if it's created by a third party, is enforceable to keep trust funds safe from creditors. And that's the end of this module. Thank you for watching. Those are pumpkins.